Welcome back to The Deep Dive. Last time, we began unpacking Timothy's monumental constitutional challenge against the family court system.
Right.
A fight he frames not just, for his family, but as a war for liberty itself, a fundamental principle that affects us all.
Absolutely. And we briefly touched on concepts like hidden foster care and how deeply ingrained parental rights are supposed to be in our Constitution. We looked at his initial complaint, his critique of no-fault divorce.
Yeah, the troubling incentives in child support, too.
Exactly. But there was one crucial, really intricate layer we didn't fully explore.
Right. A layer Timothy argues is, the very backbone of the systemic issues he's challenging.
The alleged corruption that he says makes this a battle for the soul of the family unit itself.
Yeah.
So today, we're going even deeper into the legal and societal currents underpinning Timothy's case. We're going to pull back the curtain on the intricate RHEO claims he's asserting. He's essentially arguing that the system isn't just flawed, it operates, in his view, as a criminal racketeering organization.
Wow. Okay. That's a huge claim.
It is. And this deep dive will also tackle that burning question we posed early on in our last discussion.
Right. How has such a system gone unchallenged for so long?
Exactly. What allows this injustice by default culture, as he calls it, to persist, often, right there in plain sight?
Okay, let's unpack this then. We'll delve into the specific mechanics of his RACO argument, connecting the dots between federal funding, state actions, and these alleged constitutional violations.
And then we'll pivot. Look at the historical and cultural factors that have, maybe unknowingly, allowed these issues to fester,
leading to what he calls a profound erosion of liberty. And we'll also come back to John Locke's statement about the family being the foundation of society.
Right, and Timothy's stark addition to that.
Yeah. Without the defense and protection of the family institution, there can be nothing but slavery.
Heavy stuff. It really is. So this discussion isn't just about understanding legal specifics. It's about grasping the profound societal stakes involved.
Definitely.
So if our last conversation on Timothy's initial constitutional claims intrigued you, this one builds directly on it. We're diving into the intricate how and why behind these larger systemic challenges.
Okay.
And if you haven't yet, we strongly encourage you to go back and listen to Timothy's War, unpacking the constitutional challenge to family court and hidden foster care.
Yeah, definitely worth it for the full context.
Because this deep dive really expands on those foundational issues.
All right, so to really set the stage for today's intricate discussion, let's quickly re-anchor ourselves in Timothy's initial challenge.
Good idea.
He filed a pro se civil rights complaint, that's under 42 U.S.C. Section 1983, directly attacking Colorado's family court system.
And pro se means he's representing himself, right? No lawyer.
Exactly. Which, just imagine the sheer courage, or maybe desperation, it takes to face a behemoth of a legal system entirely on your own.
It's incredibly daunting.
Yeah. And the court, in its order directing plaintiff to file amended complaint, actually noted his allegations were initially confusing and repetitive.
Which really highlights the huge procedural hurdles facing pro se litigants.
Totally. They even pointed him to the federal pro se clinic as a resource.
So it's not just a minor detail. It underscores how difficult this path is.
Right. It's a testament to the sheer will and conviction required to pursue such a systemic challenge when you're literally charting your own legal course against seasoned professionals.
What's truly fascinating here, though, is that even facing these initial procedural challenges, which, let's be honest, often derail ordinary citizens.
Yeah, they often do.
Timothy's core assertion remains about fundamental parental rights.
Okay.
And these aren't just, obscure legal concepts. The Supreme Court, in landmark cases like Troxel v. Granville,
right, we mentioned that last time,
they recognize these rights as perhaps the oldest of the fundamental liberty interests.
The oldest, wow.
Yeah. It's not just some abstract legal principle. It's a bedrock constitutional right. The liberty interest of parents in the care, custody, and control of their children is paramount.
So super important.
Extremely. Our sources, including legal scholarship, emphasize that these fundamental rights warrant what's called strict scrutiny from the state.
Strict scrutiny. Okay, what does that mean exactly?
Well, think of strict scrutiny as the highest legal bar possible. It means the state must demonstrate a compelling state interest. a really, really good, almost undeniable reason to interfere with these rights.
A compelling interest. Got it.
And even then, they must use the least restrictive means available.
Least restrictive. Okay.
Ensuring any state action is absolutely necessary and as minimal as possible to achieve that compelling interest. It's designed to be an incredibly high shield protecting the family unit from undue governmental intrusion.
So intervention should be rare and surgical, not sweeping.
Precisely. That's the ideal, anyway.
Okay, now here's where it gets really interesting and connects directly to why Timothy felt he had no choice but this profound systemic challenge. He labels current no-fault divorce statutes as a de facto legal absurdity.
An absurdity.
Yeah, akin to the only contract in the history of Anglo-American law with no enforceable terms.
Wow. Okay, break that down. No enforceable terms.
Well, think about it. Every other contract you enter into, buying coffee, a house, whatever,
Sure.
It has clear terms and consequences if one party breaks those terms.
Right. Breach of contract.
But here, Timothy argues, no-fault divorce effectively abrogates or nullifies essential elements of contract law.
So it cancels out the core idea of a contract.
Pretty much. As we touched on last time, he views it as a slap in the face of common law practice.
Right.
He's arguing that it fundamentally undermines the very notion of a binding agreement. It could potentially punish the faithful party, the one who upheld their vows, and reward the one who decided to break the contract without cause.
That's a powerful philosophical claim.
It is. It forces us to question the very nature of marriage as both a societal institution and, a legal agreement.
So it's not just about divorce itself, but a bigger shift in how society views commitment and accountability.
Exactly. Within its most basic unit, the family.
And this economic dimension, tied to the legal framework, is critical and, frankly, deeply troubling.
Yeah.
Timothy points to child support calculations. These are often based on surprisingly granular metrics, like the exact number of nights children spend with each parent.
Right, the overnights calculation.
Yeah. And this system, he argues, creates a perverse, almost irresistible incentive.
Perverse incentive? How so?
Well, it can subtly yet powerfully turn children into essentially financial assets in a parental dispute.
Oh, wow.
It incentivizes parents, or at least one parent, and arguably the system itself, to manipulate custody arrangements for monetary gain.
For more support money.
Exactly. Our sources, including Timothy's own account, emphasize this as a truly significant and troubling moral hazard.
A moral hazard.
Okay. Yeah, a situation where the economic reward for certain behaviors clashes directly with the best interests of children and, family stability.
And what makes this even worse, our sources point out, is how disturbingly easy it can be to use false accusations and restraining orders.
Right. Those could be really powerful tools.
Apparently, they can be obtained, as one source notes, without the slightest need of proof, almost on a whim.
Wow.
Without proof.
Becoming powerful, immediate weapons to rapidly isolate one parent and consolidate control, often without much substantiated evidence ever being presented in court.
And the definition of abuse itself can become incredibly elastic in this context.
Yeah, tell me about that.
Well, one source highlights how agencies might define abuse to include things like criticizing you for small things or making you feel bad about yourself.
That seems incredibly broad.
It is. And this broad subjective definition, coupled with what sources call abundant rewards for such accusations.
Rewards like what? Well, increased child support, maybe primary custody, or just a tactical advantage in court.
Right.
It can create a scenario where genuine, loving parental relationships are fractured with alarming speed and ease, all based on allegations that are really hard to challenge.
So it's a mechanism, Timothy suggests, that actively feeds that perverse incentive we talked about.
Exactly, by making it easier to leverage the system.
Okay, let's pivot now. Let's get to the heart of today's deep dive and what really sets Timothy's challenge apart. His audacious RICO claims.
Right, the racketeering angle.
He doesn't just see isolated issues, or individual bad actors. He alleges a full-fledged criminal racketeering operation masquerading as legitimate government function.
That is a very bold claim, masquerading as government function.
It's not a casual complaint. It's a bold, intricate legal assertion with profound implications. He's directly targeting the very structure of how family courts and related agencies allegedly operate.
It's a claim that demands we really understand the intricate legal framework he's using. And it raises that important question. What exactly does he mean by a racketeering organization in this context.
Yeah, because IPRA usually makes you think of, like, the mob, right? Organized crime.
Exactly, the mafia. But Timothy meticulously outlines how the Title V ED system that's a federal program meets, in his view, every element of RICO under 18 U.S.C., Section 1961 et seq.
Okay.
His argument is groundbreaking because he alleges that this powerful anti-mafia law can and should apply to government entities.
Government entities, really?
Entities that he claims are operating like a criminal enterprise. It's about proving an ongoing structured group, an enterprise engaged in a pattern of specific criminal activities known as predicate acts.
Okay, so enterprise, pattern, predicate acts. Those are the key terms.
Right. And this isn't entirely without precedent. Several sources confirm that RICO has been applied to government entities involved in corruption before.
Like when?
Well, cases like United States v. Thompson, where it was applied to a governor's office, or United States v. Angelilli, which involved a civil court in a judicial bribery scheme.
Huh.
Okay. So the core isn't necessarily a specific type of organization, like the mob, but rather a pattern of criminal activity within a structured enterprise.
Gotcha. So let's break down those elements. First, he argues for the existence of an enterprise. He describes an association, in fact. This involves not just state actors, but federal agencies at the top, like the Department of Health and Human Services, HHS,
Right.
and the Office of Child Support Enforcement, OCSE.
The federal backbone, basically.
Yeah.
Setting policies, providing funding.
Exactly. Then, at the state level, you have entities like the Colorado Judicial Department, the Colorado District Attorney's Council, the Attorney General,
Okay.
plus a group of unnamed, does 120, that legal thing for unknown people who might be identified later. And Timothy claims their common purpose is, get this, generating federal reimbursements through family destruction.
That is a stark claim. Generating money by destroying families.
Yeah.
And he asserts this isn't just a loose collection of actors doing their own thing.
No.
No, he calls it an interlocking network, operating with continuity, structure, and shared goals.
Okay. Shared goals like what?
Specifically, he alleges they are maximizing metrics like support collections and custody actions.
Metrics tied to money.
Exactly. This, he argues, is evidenced by coordinated funding formulas under federal law, 42 U.S.C., Section 658A. These formulas essentially tie state compliance and performance to federal dollars.
Ah, okay. So the money trail is key.
He claims it creates a de facto criminal syndicate, not designed for public welfare, but for profit, driven by this federal funding. The very way the system is funded, he claims, incentivizes the outcomes he's challenging.
Right, the outcomes that allegedly harm families.
Precisely.
Okay, so that's the enterprise. What about the next part? The pattern of racketeering activity.
Right, this is crucial for RICO. It's not just about one or two bad incidents.
Needs to be a pattern.
Yes. RICO requires at least 2 predicate acts within a 10-year period, demonstrating both continuity and relationship.
Continuity and relationship. Okay.
As established in landmark Supreme Court cases like H.J. Inc. and Sedema, these aren't isolated, unrelated events. They must be ongoing, related violations.
Forming either a closed pattern of repeated harms or an open continuity threatening future victims.
Exactly. It means proving a sustained, systemic approach to the alleged criminal activity. And he identifies several specific predicate acts within this alleged pattern.
Okay, let's hear them. What acts is he alleging?
Okay, first he points to mail and wire fraud.
Mail and wire fraud, how does that fit in?
This involves, he claims, false representations and support orders and court notices mailed or electronically transmitted.
False representations like what?
He argues these documents often deceive parties, saying they're acting in the best interests of children, while allegedly concealing the system's underlying revenue motives tied to that federal funding.
So using the mail or internet to basically lie about the real reasons for actions?
That's the allegation. It's about using communication channels to perpetuate the alleged fraud.
Okay. What else?
Then there's extortion.
Extortion, wow.
Timothy describes coerced payments under threat of incarceration or rights loss, as outlined in a specific Colorado statute, Section 1414-111.
Coerced payments. Threat of jail or losing your kids?
Yeah. He vividly calls this a custody ransom.
Custody ransom. That's intense.
Where state actors allegedly induce consent to payments through fear of lost parental rights.
So using fear to get money or compliance.
Right. And he cites legal precedents like Evans v. United States and United States v. Jackson for the principle that fear of economic harm or fear of losing fundamental rights like custody can be enough to prove extortion. even without a physical threat.
Just leveraging official power to compel actions against someone's will?
That's the argument.
Okay. Mail fraud, wire fraud, extortion, anything else?
Yes. He identifies obstruction of justice.
Obstruction? How?
Alleging biased tribunals, suppressing evidence, and retaliating against challengers.
So courts not being fair, suppressing evidence, punishing people who fight back.
That's the claim. It speaks to the very integrity of the judicial process. If courts aren't neutral, if they're hindering due process or punishing challengers, it undermines the whole system.
Definitely.
And finally, money laundering.
Money laundering, too.
By recycling fraudulently obtained funds through state budgets.
So hiding the allegedly dirty money by mixing it with legitimate state funds.
Essentially, yes. Suggesting a mechanism for legitimizing funds allegedly acquired through these racketeering activities, integrating them back into the public financial system.
Wow.
Each of these, he argues, isn't a mistake or an oversight. It's a deliberate action within the alleged enterprise, designed to further its objectives.
So the argument isn't just that these acts happen individually, but that they're part of a coordinated effort, right? A systemic design.
Exactly. He asserts conduct or participation in the enterprise's affairs by these defendants.
Meaning everyone plays a part.
Pretty much. Federal officials like HHS and OCSE administer the incentives, those funding formulas we talked about, while state actors, like the Colorado Judicial Department, enforce the bias statutes and allegedly carry out these predicate acts.
So each level enables the other.
That's the claim.
Yeah.
HHS and OCSE set performance metrics that, in his view, reward constitutional violations, and Colorado entities execute them through allegedly rigged courts and processes. This, he says, meets the operation or management test from the Reeves v. Ernst & Young case.
Operation or management test.
Yeah, where liability can be assigned to those who direct the funnel's daily operations, even if they aren't personally committing every single predicate act.
So the bosses can be held responsible too.
Essentially. It's an argument that the corruption isn't just happening in this system, but is the system from the top down, each component playing its part in the alleged scheme.
Okay, that's a lot. What about the interstate commerce part of RSCO? How does that apply here?
Good question. The effect on interstate commerce is established, he argues, through several channels. First, those nationwide funding flows. Billions of dollars moving between the federal government and states.
Okay, money crossing state lines.
Right. Second, cross-state enforcement mechanisms. Things like parental kidnapping laws that can involve crossing state lines or interstate child support enforcement.
Makes sense.
And third, the widespread economic impacts on families that span borders. Family dissolution often means parents and kids living in different states.
True.
All of these, he argues, meet the minimal nexus required for ICAICO claims. It's a standard that's actually quite broad, based on cases like United States v. Robertson and Gonzalez v. Raich.
So even local stuff can count if it affects commerce overall.
Exactly. The argument is that the alleged racketeering isn't confined to just Colorado. Its mechanisms and impacts ripple across the nation, making it a federal issue under ICAICO.
Okay. And the final piece, the injury to business or property.
Right. Timothy argues that he and countless others suffer concrete financial injuries.
Financial injuries, like what? Lost money?
Yes. Lost income from coerced payments, massive legal fees.
Oh yeah, family court legal fees can be astronomical, crippling.
Absolutely. But also, significantly, the deprivation of parental rights itself.
Losing time with your kids or custody.
Yes. And this is a key point. The Supreme Court, again in Troxel v. Granville, explicitly recognized parental rights as a property interest.
Parental rights are property, legally speaking.
Legally speaking, yes. So the loss of these rights isn't just an emotional or familial injury, it's a recognized legal property loss.
Ah, interesting.
He cites cases like Holmes and Rotella for the concept of proximate cause, asserting that these financial and fundamental losses are directly and demonstrably caused by the alleged racketeering activities.
So it's not abstract suffering. It's concrete, measurable harm directly caused by the alleged scheme.
That's the argument he's making.
Wow. Okay. So connecting this all back, what's the big picture claim here?
Well, Timothy's filing makes a truly stark claim. Constitutional compliance is economically canalized.
Okay.
And conversely, constitutional violations are financially rewarded.
Violations are rewarded?
He argues that under Title 4DD's formulas, again, 42 U.S.C., Section 658A, any efforts by states to protect parental rights or uphold family integrity actually reduce metrics like divorce rates and child support collections.
Which reduces their federal funding.
Exactly. It slashes federal funds, creating what he calls a structural disincentive for due process.
A disincentive for doing the right thing constitutionally.
Think about that. A system where upholding fundamental constitutional rights actually costs the state money. This, he claims, entrenches the racketeering by directly threatening the enterprise's financial lifeblood.
Wow.
Conversely, incentives reward dissolution through custody actions, conflict generation via biased domestic violence proceedings, and aggressive support extractions.
So breaking up families and generating conflict actually pays.
That's the assertion. This, he states, funnels billions annually, effectively transforming the pursuit of justice into a marketplace of misery.
Marketplace of misery. That's grim.
He points to precedents like United States v. Schenberg and United States v. Maloney cases, involving judicial racketeering as examples. He also claims that unenumerated parental rights under the Ninth Amendment, like autonomy, financial self-determination, are essentially exterminated under color of law.
Just wiped out.
It's a profound accusation of institutional corruption, where courts are allegedly corrupted into revenue enterprises.
Okay. It's a comprehensive and deeply troubling argument. A system allegedly designed to monetize the very constitutional violations it should be preventing. So, what's Timothy's ultimate goal here? What does he want the court to do?
Well, as outlined in his requested remedies in the memorandum, he's not asking for minor adjustments or, incremental reforms.
No small tweaks.
No, he's asking for a complete dismantlement of Title IV revenue generation apparatus.
Dismantle the whole funding system.
And structural reform, eliminating financial incentives for constitutional violations.
Get rid of the money motive.
Right. This includes the radical, far-reaching step of declaring several Colorado statutes, the ones related to no-fault divorce, domestic violence, protection orders, parental rights, child support, declaring them facially unconstitutional.
Strike down the laws themselves.
Yes. He's not just tweaking the system, he's aiming for a full paradigm shift, asserting that only a root and branch removal of these financial incentives can restore constitutional order and genuinely protect families.
It's an ambitious legal gambit, for sure.
But one he clearly views as essential.
Okay, this all raises that crucial question we posed earlier, and it's one Timothy himself asks in his filings, right?
Yeah, he does.
How has such a profoundly problematic system, as he describes it, gone on unchallenged for so long?
It's the elephant in the room, isn't it?
He observes, how hollow is the lip service paid to the Constitution by our rulers, while such a profoundly illegal institution endures, eroding liberty at its core.
Strong words.
Yeah. He suggests it's a combination of things: the sheer complexity of the legal system, and what he calls the complacency of the public, and injustice by default culture.
Injustice by default.
He speaks from painful personal experience about fighting what he describes as a seemingly invisible corruption.
A maniacal and psychotically possessed system, he calls it.
Yeah, that has kept him trapped for years. For most of us, this level of alleged systemic corruption remains unseen, right? Which makes it all the more insidious.
Absolutely. It makes you wonder, why don't more people recognize it or challenge it?
Exactly.
And that's a crucial point. What's fascinating here is how the legal system's inherent complexity acts as this powerful, almost impenetrable barrier.
Right. We saw that with the court's initial reaction to his filing.
Exactly. The court finding his pro se complaint confusing and repetitive, and asking for a manageable and readable format.
Yeah.
That isn't criticism of Timothy. It highlights the daunting, often impossible task facing individuals without extensive legal training.
The system just isn't designed for the average person to navigate effectively.
Pretty much. And our sources also highlight other significant hurdles, like legal immunities.
Immunities? Like what?
Well, prosecutors, for example, are largely protected from civil liability for actions taken in their official capacity. That was established in Imbler v. Pachman.
So you can't easily sue a prosecutor?
Generally, no.
Yeah.
And states themselves often enjoy sovereign immunity under the 11th Amendment, largely shielding them from being sued in federal courts by private citizens.
Okay, so layers of protection for the system itself.
Right. These immunities make it incredibly difficult to hold specific actors or even entire state entities accountable. It further complicates any challenge to the system's alleged corruption.
It creates a shield, allowing problematic practices to persist without easy recourse.
Precisely.
And it goes beyond just, confusing paperwork and legal immunities. Think about how dependency courts often operate.
Right, compared to criminal courts.
The contrast is stark. Sources like the state-run child trafficking industry highlight a truly alarming difference.
What's that?
In dependency court, the sentence, like removing a child from their home, often happens before a single hearing has even taken place.
Before a hearing?
Think about that. A child separated from a parent based solely on a social worker's recommendation, often without judicial review or the parent even getting a chance to present their side.
That sounds backwards.
In these courts, there's typically no presumption of innocence for parents, no jury trials. Parents can even be denied counsel.
No lawyer.
Which dramatically shifts the burden of proof from the state onto the parent.
So the parent has to prove they're fit instead of the state proving they're unfit.
Exactly. Contrast that with criminal court. Defendants usually get bail. They're presumed innocent until proven guilty beyond a reasonable doubt. Clear right to an attorney.
A completely different world.
It makes it incredibly difficult for parents who are often already under immense emotional stress, facing a powerful state apparatus to adequately defend their constitutional rights.
And you also have the issue of lawyers who might be overwhelmed.
Yeah, frazzled, ill-prepared lawyers, as one source put it. Huge caseloads, maybe not the specialized training needed for these complex, fast-moving cases.
And then there are the strict confidentiality laws.
Right. Which make it difficult to evaluate individual cases and bring systemic issues out into the open.
So everything happens behind closed doors, essentially.
Pretty much, which then raises this important question about transparency, or, the lack thereof.
Definitely.
The We Spoke group, for example, highlighted a particularly egregious practice they found in New York.
What was that?
The New York Civil Liberties Union learned that the Office of Court Administration was actually issuing secret directives to judges.
Secret directives. Telling them how to rule.
Basically instructing them on how to interpret court decisions that affected important constitutional rights. And these memos weren't public.
Wow. That sounds fundamentally wrong.
The NYCLU argued it does a disservice to the public's interest in the transparent administration of justice and violates freedom of information laws.
You think? Secret instructions to judges totally undermines public trust and the whole idea of open courts.
Exactly. A lack of transparency can certainly allow problematic practices to persist, even flourish, out of public view, shielded from scrutiny.
When critical instructions to judges are kept secret, it creates an environment just ripe for the kind of institutional corruption Timothy alleges.
Okay, so beyond the legal labyrinth and the secrecy, there's this profound issue of public complacency and deep-seated cultural norms.
Right. The injustice by default idea.
As one source, .pdf, puts it so well, the commonplace is often almost invisible. The most common injustices are hardest to see.
Hardest to see because they're just normal.
Exactly. This injustice by default can be particularly insidious when it comes to family law, where biases have really deep historical roots, often hidden in plain sight because they've become so normalized over generations.
We as a society tend to accept what we see daily as just the way things are, right? Without questioning the underlying assumptions or historical influences that shaped them.
It's a psychological thing, isn't it? The sheer ubiquity of something, even if it's flawed, makes it blend into the background.
Yeah. We stop seeing the cracks because they're part of the everyday landscape, making systemic change incredibly difficult until someone like Timothy actively points out the absurdity and demands we look closer.
Right.
And if we connect this to the bigger picture, historical gender bias has played a truly significant role in creating this default setting.
Gender bias? How so?
Well, think about the tender years doctrine. Historically, that favored mothers for child custody.
Okay.
Or the pervasive motherhood mystique, which elevated mothers as these primary and irreplaceable caregivers.
Right. The idea that mom is naturally better suited.
Exactly. These concepts, deeply embedded in legal and social thought for decades, effectively marginalized fathers.
Push them to the side.
Our sources, like Lagging Behind the Times, detail this feminization of the home front and fathers' long march from the center to the periphery. And even when these supposedly gender-neutral best interests of the child standard replaced these doctrines.
Which is what we use now, mostly.
Right. But national statistics still show a striking disparity. Mothers receive primary custody in overwhelming numbers, like 87% of children living with single mothers compared to just 13% with single fathers.
87 to 13, that's a huge difference.
It is. This disparity persists despite the stated neutrality of the law, suggesting that implicit biases continue to influence outcomes.
So the old ideas are still shaping decisions.
It seems like it.
Mhm.
For instance, a deeper analysis of the Massachusetts gender bias study, which is often cited to claim fathers obtain custody 70% of the time when they seek it, actually revealed that mothers receive custody in 93.4% of cases overall. The narrative and the reality often diverge significantly.
Wow. Okay. So this marginalization of fathers isn't just abstract legal stuff. It has real societal consequences.
Oh, absolutely.
Yeah.
Tangible, often devastating consequences. Studies cited in Lagging Behind the Times show a clear correlation.
What kind of correlation?
Children without fathers are more likely to suffer increased psychological, educational, behavioral, and health disorders.
Wow.
And our society is more likely to suffer increased crime and violence. For example, an HHS study found kids with never-married mothers were significantly more likely to be expelled, have emotional problems, engage in antisocial behavior.
That's serious.
Children in single-parent families are consistently 2 to 3 times as likely to have emotional and behavioral problems compared to those in two-parent households.
It's like a feedback loop, then.
Kind of. A devalued role for fathers leads to negative outcomes, which unfortunately reinforces the societal idea that fathers aren't as essential, even when strong evidence points the other way.
And adding to this, another source highlights a really tragic, often unspoken reality.
What's that?
That children are as much as 33 times more likely to be abused when a live-in boyfriend or stepfather is present compared to intact families. 33 times, that's staggering.
It is. And disturbingly, the same source points out that mothers accounted for 55% of child murders in 1994, while fathers were a relatively tiny percentage.
So the system, trying to remove alleged abusers, might inadvertently put kids at even greater risk sometimes.
It suggests a tragic perversion where that can happen, yes.
Wow. Okay. This also links back to how easily that definition of abuse can be stretched and, well, weaponized.
Right. The ambiguity allows for what's termed objectionable coercion.
Objectionable coercion.
Where Child Protective Services agencies might insist on safety plans, even without strong evidence of neglect or abuse.
Safety plans, those are the agreements outside of court.
Right, exactly. As discussed in America's hidden foster care system, Judge Richard Posner, in the Dupuy v. Samuels case, distinguished between legitimate state actions and objectionable threats, legally unjustifiable coercion that forces parents into agreements.
But it still happens.
Apparently. In the Proft case, for example, CPS required a parent to prove beyond any certainty that there was no sexual abuse.
Wait, prove a negative. Prove something didn't happen.
Yes, which is a stark example of an unconstitutional shifting of the burden of proof from the state to the parent.
Instead of innocent until proven guilty, it's guilty until you prove yourself innocent.
Essentially.
Yeah.
This creates a system where objectionable coercion isn't a bug, it's a feature, especially when those financial incentives are potentially involved.
So parents, terrified of losing their kids, agree to these restrictive safety plans out of fear.
Often, yes. Effectively bypassing the legal safeguards of a court order and judicial review, often without even having a lawyer present.
Wow.
It bypasses due process.
And we can't ignore what that We Spoke group called the festive divorce industry.
Right, the predatory divorce industry with zero accountability.
Zero accountability, because courts often operate behind closed doors. This isn't just about individual cases going wrong.
No, it implies something more systemic.
Yeah, that far from being an objective arbiter seeking swift, fair resolutions, the system itself can become incentivized to perpetuate conflict and prolong disputes.
Because conflict generates fees and keeps the system busy.
Exactly. The We Spoke group's petition called for mandatory 6-month child custody determinations, precisely to stop families from spending years at the mercy of a predatory divorce industry.
Trying to speed things up and limit the damage.
And this aligns with Judge Page's observation that improving court status often aims to increase caseload.
Increase caseload, not necessarily improve outcomes.
Suggesting a business model where, quote, the better the family court system functions, the higher the volume of the persons served.
So success is measured by volume, not necessarily by justice or family well-being.
That perspective suggests a system that thrives on ongoing disputes and the associated legal fees, rather than on promoting stability and reconciliation.
And this dynamic extends powerfully to child support enforcement, too, creating significant hardship that can further destabilize families.
How so?
Well, some state child support guidelines, as cited in that Baskerville source, have actually been deemed unconstitutional by state courts.
Unconstitutional? What?
Found to create a windfall to the allege, the custodial parent, often leaving the non-custodial parent in poverty, while the custodial parent enjoys a higher standard of living than they might have had in an intact family.
So one parent gets way more, the other struggles immensely.
Yes. And despite these rulings, some state agencies, like the Tennessee Department of Human Services, apparently announced they would just ignore these court decisions.
Let's ignore the courts.
That's what the source claims. Our sources also highlight the argument that child support is paid only when it's paid in a bureaucratically acceptable form.
Meaning?
Meaning that men providing non-monetary support, like buying clothes, school supplies directly for the kids, are often still deemed deadbeat dads by the system.
Because only officially documented payments count?
Exactly. The economic hardship on fathers in particular can be immense.
Like what kind of hardship?
Loss of jobs, homelessness, revoked professional licenses, even driver's licenses, and even starvation policies that could render poor parents ineligible for essential things like food stamps.
Wow. It's not just about money, it's about stripping people of their livelihoods and basic rights.
That's the argument. A system that can, by design, do that, ostensibly in the name of child welfare, but with profound and often devastating negative consequences for those trapped inside.
Ultimately, all of this seems to point to a deep institutional corruption, where government policies inadvertently, or as Timothy argues, quite deliberately create a perpetual growth machine.
How does that work?
Well, as detailed in the article, is there really a fatherhood crisis? The argument is that by identifying fathers as the culprits behind family dissolution, rather than addressing systemic government failures.
Shifting the blame.
Right. The state justifies harsh enforcement and creates an unlimited supply of problems for itself to solve, instead of honestly addressing its own role and maybe exacerbating social issues.
It devises elaborate schemes to deal with the problems its own policies helped create.
Exactly. Expanding its own reach, power, and budget in the process.
A self-perpetuating cycle.
That, as our sources state, neutered the principal rival to its power, the family, and created an unlimited supply of problems for itself to solve.
Wow. That's a cynical view, but it connects the dots.
It does.
And it's a system where, as Timothy observes in Letter to My Children, the state tells them it's a patriarchy, and they have submitted themselves emotionally to the authority of the state, so it's a patriarchy, and that's it.
Emotional submission to the state's narrative.
Yeah. This idea, coupled with the lack of critical examination, can perpetuate cycles of injustice, particularly, he argues, for men.
Right.
He speaks from painful personal experience of how society itself is eager and willing to utterly crush any male weakness expressed.
So men are discouraged from speaking out about their struggles.
Exactly. This societal dynamic, he argues, leads to men internalizing their struggles, not expressing their feelings. And thus society doesn't understand their struggles.
Further entrenching that injustice by default culture.
Right. Making it harder for these issues to be seen, let alone effectively challenged. It's a cycle of silence and systemic harm.
Which brings us to the really profound societal implications of Timothy's challenge.
Yeah, the bigger picture.
The influential philosopher John Locke famously wrote that family is the foundation of society.
A cornerstone idea in Western thought.
Right. But Timothy adds this powerful, almost chilling extension to it.
What's that?
Without the defense and protection of the family institution, there can be nothing but slavery.
Wow. Nothing but slavery. That's extreme.
It sounds extreme, but for him, it's not hyperbole. It's a deeply felt truth forged in the crucible of his own fight.
Right.
He believes his current struggle is literally a war against this entire corrupt system, a fight specifically for his children.
One he's committed to waging until death or victory.
Yeah. For him, the stakes couldn't be higher. It's about the very essence of liberty, the future of his family, and by extension, all families.
And this core belief is deeply rooted in that recognition of parental rights as fundamental to a free society.
Back to those fundamental rights.
Yeah. The Supreme Court has long affirmed, in cases like Prince v. Massachusetts, that the custody, care, and nurture of the child reside first in the parents.
Reside first in the parents, not the state.
Right. And that children profoundly benefit from strong parental relationships. Yet, as we've discussed today and last time, these rights are routinely undermined, often through ambiguous legal standards like that best interests of the child standard that lack clear objective definitions.
Which makes them easy to manipulate, maybe.
Potentially, yes.
Yeah.
And what's also crucial and often overlooked is the child's independent right to family integrity.
The child's right.
Yes. While not explicitly defined by the U.S. Supreme Court, this right is strongly supported by language in cases like Stanley v. Illinois and, importantly, by international conventions like the UN Convention on the Rights of the Child.
What does that say?
It unequivocally states that family is the fundamental group of society and the natural environment for the growth and well-being of all its members, and particularly children.
Okay. So, internationally recognized.
These foundational principles are precisely what Timothy argues are under systemic attack by the current family court apparatus.
Gotcha. And one of the most criticized elements in family law is indeed that best interests of the child standard.
Right. It sounds good, but it's problematic.
How so? Many legal experts argue it's unconstitutionally vague.
Vague, meaning it doesn't give clear guidance.
Exactly. Providing no real guidance and highly susceptible to cultural, class, religious, ethnic, and racial biases.
So judges' personal biases can creep in easily.
That's the concern. As yes, Virginia, the Constitution applies in family court, 2 points out, it can turn courtrooms into what are described as constitutional twilight zones.
Constitutional twilight zone.
Okay, where judges, in the name of children's best interests, can illegitimately violate parental rights.
And state Supreme Courts have even found this standard unconstitutionally vague in related contexts. Cases like Richmond v. Case and Michael Levy State in Nebraska.
So there's legal precedent for questioning it.
Yes. It essentially gives judges enormous, almost unchecked discretion, which can lead to inconsistent and deeply biased outcomes.
This vast judicial discretion, unconstrained by clear legal parameters, further erodes constitutional protections for parents and children alike, makes the system unpredictable, often arbitrary.
Which raises that important question. How can we correct this? How do we fix this profound ambiguity and restore constitutional order?
Yeah, what's the solution?
Well, one key proposal, detailed extensively in that Yes, Virginia article, is to shift away from the subjective, vague, best interests standard to a presumption of joint legal custody and equal parenting time.
A presumption of equality from the start.
Exactly. Every case would start from a position of shared parental responsibility and equal time, reflecting the constitutional right of both parents to their children.
Okay. What if that's not possible or safe?
Then any deviation from this presumption would require clear and convincing evidence. That's a high legal burden.
Right.
That is justified by the least restrictive means available.
Back to least restrictive means.
Yes. This approach would compel courts to focus on upholding constitutional rights first, rather than imposing subjective views of what's best based on personal biases.
Makes sense.
It also suggests practical, less restrictive solutions like tiebreaker provisions for parental conflict, which are a far better alternative than just granting sole custody and severely limiting one parent's involvement.
So find ways to make joint custody work before taking it away.
Precisely. This shifts the burden back to the state to prove harm rather than forcing parents to prove their fitness. It restores a critical constitutional safeguard.
Okay. Beyond changing the judicial standard, what else? There was talk about hidden foster care.
Right. There's a strong, urgent call for greater transparency and regulation in that area.
What does that involve?
Our source, America's Hidden Foster Care System, discusses the alarming dearth of hard data. We just don't know enough about it.
So first step is collect data.
Yes. Mandating that states gather and report comprehensive data on children placed through these safety plans, those informal custody arrangements that completely bypass court oversight.
Okay. Why is that important?
The goal is twofold. First, to make the invisible visible, understand the scope of the problem.
Right.
And second, to ensure that physical custody changes only when legally warranted, with robust due process and support for all parties involved.
Due process, even outside of court.
Yes. This includes a clear right to legal representation for parents before they are pressured into agreeing to a safety plan.
Get a lawyer before you sign anything.
Exactly. Because parents are often coerced without understanding the full implications of signing away their rights.
Even though the Supreme Court said there's no absolute right to counsel in termination cases.
Right, that was Lassiter. But advocates are fiercely pushing for this protection in the context of safety plans, recognizing the profound and often irreversible implications. This is about shining a light on practices that operate entirely in the shadows and holding the system accountable.
Okay. Transparency, data, legal counsel. What else?
There are also calls for robust court watch programs.
Court watch, like citizens observing court.
Exactly. As advocated in Lagging Behind the Times, to empirically examine custody decisions in real time, collect objective data on custody awards, rather than relying on subjective surveys or anecdotes.
Get real numbers on what's actually happening.
Yes, invaluable in identifying and addressing gender-biased applications of supposedly gender-neutral laws.
Makes sense.
Furthermore, there's a push for trial judges to be required to provide written findings supporting their decisions.
Explain why they ruled the way they did in writing.
Exactly. This would bring much-needed accountability to a system that often operates in the shadows, where the rationale for life-altering decisions can remain opaque or just unstated.
So transparency through data, independent observation, and mandatory written justifications.
Right. These measures would help ensure that judicial decisions are sound, fair, based on fact, not arbitrary judgment, allowing for meaningful review and hopefully greater justice.
Okay, so it really boils down to recognizing the inherent value and integrity of the family unit itself. As Timothy underscores, where true liberty involves the citizen's right to pursue mastery unencumbered by the state.
Mastery unencumbered by the state.
Yeah. In codeofrebellion.md, he sees his fight as contributing to a just rebellion, a righteous uprising, to clear the fog and expose the obscured playing deck, the hidden rules of the game.
Try to level the playing field.
Right. And he warns that if the status quo persists, we risk descending into an authoritarian nightmare, where everything is monitored, every aspect of our lives controlled, and the spirit of rebellion, the very essence of challenging injustice, is crushed.
That's a stark warning.
He views this current system as a deliberate corruption by a royal class that stifles the path to individual mastery and erodes justice.
And as he expresses so powerfully in Letter to My Children, he's personally committed to ensuring his children have a father unhindered and unable to be controlled by the corruptions of state or outside influence.
It's not just a legal battle for him, it's deeply personal.
A quest for self-determination and the protection of foundational liberty for future generations. Hashtag outro.
So, wow, what does this all mean for us? Timothy de Herrera's deep dive into the constitutional bedrock of family law, his comprehensive Rico challenge, his unwavering pursuit of justice. It lays bare a system that, well, whether by design or by default, appears to systematically erode fundamental parental rights.
And by extension, the very fabric of society.
He's not just seeking personal redress, he's fighting for a paradigm shift that could impact every family, every citizen, compelling us to look closer at the institutions we often just take for granted.
Assuming they're always working in our best interest.
Right.
And this exploration challenges us to consider not only the legal intricacies, which are dense,
Very dense.
but also the profound societal complacency that allows such systems to persist. It raises the provocative thought that maybe the biggest threat to liberty isn't always a direct, overt assault, but a gradual, invisible erosion of foundational rights, especially within the seemingly private sphere of the family unit.
When the commonplace becomes invisible, injustice can thrive, shielded by its very ubiquity.
Exactly. What stands out to you from this intricate exploration? All these legal frameworks, historical biases, the profound societal stakes.
It's a lot to process, but the issues Timothy's raising really compel us to consider if the family is, as Locke said, the foundation, and that foundation is under stress from within systems ostensibly designed to protect it. What does that mean for the entire structure of our society?
It's a fundamental question.
What responsibility do we as citizens have to question, to investigate, to demand transparency and justice in systems that often operate largely out of public view, impacting the most vulnerable among us?
As John Locke and Timothy de Herrera remind us, the strength of our society is inextricably linked to the protection of its families.
Yeah.
The question that remains is, what will it take for us to truly see and then to act before the stakes become even higher, and the erosion of these fundamental rights becomes irreversible?